Hello and welcome to Unacademy. Today is the sixth and the last lecture of the series, The Polity Project. We have covered 5 lectures already. Today is lecture number 6, and today we shall discuss Article 3 of the Constitution, the reorganization of the Indian states, and we will also discuss how Jammu and Kashmir was bifurcated into Jammu and Kashmir and Ladakh as 2 union territories. And if this polity project has helped your conceptual understanding of Indian polity, do let me know in the comment section, and do not forget to subscribe to our channel if you haven't yet. Let's get started, and first up, let's look at federalism. In federalism, there are 2 units. One is center, the other states. But states are not subservient to the center. States are not inferior to the center. Both center as well as states, they derive their authority from the Constitution. It is the Constitution which has allocated powers, functions, and roles to both center as well as the states. For example, there is dual government. One government in the center, the government in every state. And then Constitution has mandated something called distribution of powers. Center, for example, the union legislature, it is empowered to make laws on subjects such as citizenship, defense, external affairs, communication, banking, insurance. State legislatures, on the other hand, they have the power to make laws on subjects such as law and order, police, agriculture, gambling, so on and so forth. Which means Constitution has clearly delineated the roles and responsibilities of the center as well as the states. But this is where we deviate from the US model of federalism, which is considered to be the oldest federal constitution of the world. How? Listen to me carefully. But before I tell you about US model and how we have deviated from the US model, if you are preparing for the civil services exam, whether for 26 or 27 or 28, and if you wish to be taught by these teachers on your screen, then consider subscribing to our UPSC courses. Because right now, Unacademy has lowered the subscription fee across UPSC courses. If you're preparing for 2026, you can get 12 months UPSC course subscription at 17,999. Go to our website. You may see different price being quoted on the website, but once you apply this code IAS English, automatically the lowest price will be displayed on the screen. If you are preparing for the civil services, if you want a guided program where GS, CSAT, current affairs, answer writing, everything is included so as to help you crack the civil services examination in your first attempt. But coming back to the discussion, federalism, where I told you that there are 2 units, center and states. States are not subservient to the center. Center and states, they derive their authority from the Constitution. Some areas are allocated to the center, some areas are allocated to the states. There is dual government, there is distribution of powers. But why do countries embrace federalism? Why not a unitary form of government? And in a unitary form of government, all powers are concentrated in one strong center. For example, South Africa. For example, United Kingdom. For example, Spain. They don't follow federal system where there is distribution of powers among center and the states, clearly allocated roles and responsibilities. Constitutional expert Philip Marwood, he says countries such as India, which is culturally diverse, geographically vast, it has embraced federalism not because of administrative convenience, but because of the very survival of the nation. Normally, we embrace federalism, distribution of powers, so as to aid in administration, so that administration becomes convenient. You have certain responsibilities, we have certain responsibilities. Let's divide the responsibilities amongst each other so that we can govern the country better. So for administrative reasons, there is federalism or a federal polity or a federal government. But Philip Marwood says a country such as India, which is culturally diverse, geographically vast, it has embraced federalism not only because of administrative convenience, but because of the very survival of the nation. Because if all the powers are concentrated in one strong center, then what will happen to the diverse states that we have? And listen to me carefully when I say that in India we have reorganized the country into various states on linguistic lines. So there is a Tamil Nadu, there is a Karnataka, there is an Odisha, there is a Kerala, there is Punjab, there is Gujarat, there is Maharashtra. States have been reorganized along the lines of language. Why? Because we are diverse. And if one authority, all the powers would have been concentrated in one authority, in one strong center, maybe states would not have been in a position to embrace and protect their unique identity and culture. And there was a risk it may lead to balkanization of the country. That is why Philip Marwood argues that a country such as India, it has embraced federalism because of the very survival of the nation. Otherwise, the nation may not have survived together. But even if we have embraced federalism, but we have deviated from the US model of federalism in a sense that our constitution has created a strong center. Instead of equally allocating roles and responsibilities to the center and the state, our constitution has concentrated more powers in the hands of the center as against the states. Pandit Nehru said, it won't be prudent for us. It won't be good if we create a weak center. We need a strong center, which means we need a center which is more powerful than the states. Why? Because if we have a strong center, we will be able to ensure peace. For example, there is a threat to our sovereignty and integrity of the nation, but army reports to the central authority, army, navy, air force. So if the powers are more given to the center, it will be in a much better position to secure peace, to coordinate vital interests, to speak in one voice in the international forum. For example, what is our policy on the Russia-Ukraine conflict? If we give this responsibility to the states, states may not speak in one voice. Different states may have different views on this Russia-Ukraine conflict or Palestine-Israel conflict or the conflict that we see in Nepal. But since international relations or external affairs is under the control of the center, we are able to speak in one voice in the international forum on these important matters. That is why if you look at the constitution, under Article 1, it says India, that is Bharat, shall be a union of states. And this term union is used and not a federation. Federation basically means more states, they will come together to create a political entity, and that entity is a federation. For example, in United States, it was not a United States. These were 13 British colonies. They revolted against the British. They liberated themselves in the American War of Independence. And now these 13 British colonies, which have now declared independence, they wanted to come together through a treaty, through an agreement, to create a political entity called United States of America. And then they gave themselves a constitution, where what is going to be the role of the states, what is going to be the role of the central authority, federal authority, we will clearly mention it in the written constitution, which was adopted in 1787. The point is that in federalism, normally it is a treaty, it's an agreement between states. When states, they decide to come together to create a political entity. Dr. Ambedkar said, although we are a federal polity, and Supreme Court has said in S.R. Bommai v. Union of India, that federalism is part of the basic structure of the Indian Constitution, a landmark judgment given by the court in 1994. Supreme Court said federalism is part of the basic structure. Dr. Ambedkar said we have a federal polity. But despite that, I have used the phrase union of states and not federation of states because of two reasons. Reason number one is India is not the result of an agreement between states. It's not that the states have come together through a treaty, through an agreement to create this political entity called India. There was no such negotiation which took place. And at the same time, if the states have come together to create a political entity through a treaty, through a contract, maybe a state may want to come out of that treaty as well. Maybe the state will secede from the federation. That is why Dr. Ambedkar said, I have used the phrase union of states and not federation of states in Article 1 because of these two reasons. Because India is not the result of an agreement between states, and no state has the right to secede, to come out of the Union of India. So although we are a federal polity, ours is a federal constitution, but we deviate from the US model in a sense that our constitution has created a more powerful center as compared to states. And this is reflected in Article 3 of the Constitution. There are certain provisions in the Constitution which we call centralizing tendency of Indian federalism. Despite the fact that we are a federal polity, but there are some provisions which make center more powerful, more strong as compared to states. One such example is Article 3 of the Constitution. What Article 3 says? Parliament has the power, not the state legislatures, Parliament, which is the union legislature. Parliament has the power that their parliament, you can enact a law. And through that law, what you can do, you can bifurcate a state. You can merge states. You can increase the area of a state. You can decrease the area of a state. You can alter the boundaries of the state. You can change the name of the state as well. All this is the power available with the central legislature, parliament, center, and not the states. That means even if states refuse to be bifurcated or trifurcated or merge with another state, Parliament will have the final word. That is a centralizing tendency of Indian federalism. But for this, there is a consultative process provided in the Constitution itself. And what is that consultative process? For example, Andhra Pradesh was to be bifurcated because there was a demand. The demand from the people of Telangana was that we have been discriminated against. Jobs are given to the people of the coastal Andhra, the Rayalaseema region, but the people belonging to the Telangana region, they have been discriminated against. And for that, we have one demand. We want a separate state of Telangana carved out from Andhra Pradesh, which means Andhra Pradesh needs to be reorganized. It needs to be split into Andhra Pradesh and Telangana. Who has that power? That power is with the parliament. How parliament will bifurcate Andhra Pradesh? By passing a law. But before enacting that law, before presenting this bill before the parliament, because what is this bill? Bill is a proposal. Andhra Pradesh Reorganization Bill of 2014. It's a proposal. The proposal is to bifurcate Andhra Pradesh into Andhra Pradesh and Telangana. Such a bill cannot be introduced in the parliament without the prior approval of the President of India. Which means first the President will have to agree and approve that, okay, the government, you can introduce this bill in the parliament. But before President can give her approval, President will have to refer this bill to the legislature of that state, which is going to be affected by this bill. Which means the President will have to refer this bill to Andhra Pradesh Legislative Assembly, because it is this Andhra Pradesh which is going to be affected by this bill. After all, it is going to be bifurcated. And why the President will refer this bill to that legislature? So that that legislature can give its views. But even if these views are not acceptable to the central government, these views are not binding. That means President can still go ahead, allow the government to introduce this bill in the parliament and bifurcate the state, which is exactly what happened in 2014. When this Andhra Pradesh Reorganization Bill was sent to the Andhra Pradesh legislature passed a resolution rejecting this bill. Even then, the President went ahead, gave permission, approval to the government, introduced this bill in the parliament. Both houses of the parliament passed this bill by simple majority, and then Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. But the point is, how Jammu and Kashmir was bifurcated. And this is where it becomes interesting. Why interesting? Because till 2019, till August 5 of 2019, Jammu and Kashmir had a special status. And that special status was conferred because of Article 370 of the Constitution. And I'll tell you in simple terms what Article 370 vis-a-vis Article 3 meant. If Parliament has the power to bifurcate a state, even against the wishes of that state, this could not have happened for Jammu and Kashmir, because Jammu and Kashmir had a special status. Without the concurrence of Jammu and Kashmir government, the Parliament could not have bifurcated the state, could not have reorganized the boundaries of Jammu and Kashmir. That was not the power available with the Parliament. And that is why we argue that Jammu and Kashmir shared a perfect federal relationship with the center. But then this special status was diluted, revoked on August 5, 2019, and the entire Indian Constitution became applicable to Jammu and Kashmir. When we say entire Indian Constitution, which means Article 3 as well, which means now Article 3 can be invoked to bifurcate, to reorganize Jammu and Kashmir. And for that, a bill had to be introduced in the Parliament known as Jammu and Kashmir Reorganization Bill. But this was something different. Different in the sense, previously we saw a state getting split into two states. Uttar Pradesh was bifurcated into Uttar Pradesh and Uttaranchal. Later it became Uttarakhand. Madhya Pradesh was split into Madhya Pradesh and Chhattisgarh. Bihar was split or reorganized into Bihar and Jharkhand. Andhra Pradesh in 2014 was reorganized into Andhra Pradesh and Telangana, but as states. For the first time since 1956, a state was downgraded to two union territories. It's not that Jammu and Kashmir was created as a state and Ladakh as a separate state. Both these entities were downgraded to that of a union territory. And for that, this bill had to be introduced. This bill, which was cleared by the Union Cabinet, it was sent to the President. President said, but I need to seek the views of Jammu and Kashmir Legislative Assembly, because views I have to seek. That is the consultative process, which is mentioned under Article 3. But curiously, Jammu and Kashmir then, the Legislative Assembly had been dissolved, and the state of Jammu and Kashmir was under President's rule. When the state is under President's rule, the legislature for that state is the Parliament. That means Parliament will act as the legislature of that state. Which means when this bill was cleared by the Cabinet, it was sent to the President. President had to send it to the legislature of that state. But since they don't have a legislative assembly, President referred this bill to the Parliament, because Parliament is acting as the legislature for the state of Jammu and Kashmir for time being, because the state is under President's rule. And Parliament gave its view by passing a resolution accepting Jammu and Kashmir reorganization. So once this Jammu and Kashmir reorganization bill, on this views were taken from the Parliament, President asked the government, introduce this bill in the Parliament, both houses of the Parliament passed the resolution, passed this bill by simple majority, and Jammu and Kashmir was bifurcated into Jammu and Kashmir and Ladakh, two union territories. But the difference was Jammu and Kashmir and Ladakh, both these are union territories, but Jammu and Kashmir will have a legislative assembly, which they have right now. And Ladakh would be a union territory without a legislative assembly. Matter went to the court. My lord, this Jammu and Kashmir Reorganization Act is unconstitutional. Why? Because it violates federalism. And this federalism is part of the basic structure of the Indian Constitution. How did the Supreme Court look at this case? Article 3, once you read, it says Parliament has the power that by enacting a law, it can merge states, it can split states, it can increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name of the state. But does that include the power to make a union territory from that state? To carve out a union territory from that state? Yes, that's the power. If you read Article 3, Explanation 2 of Article 3, this power of the Parliament to reorganize a state includes the power to create a union territory, to carve out a union territory. That's the power. But Constitution is silent. On what aspect? Whether the entire state can be downgraded to that of a union territory. That means it may be possible, and it is possible, that the state of Jammu and Kashmir, a part of the state which is Ladakh, was split from Jammu and Kashmir and converted into a union territory. Is that possible? Yes. Is that allowed under Article 3? Yes. Explanation 2 of Article 3 allows it. And this is what Supreme Court said: we uphold the creation of Ladakh as a union territory. So we don't have a problem. There is no dispute about the creation of Ladakh as a union territory, because a part of this territory has now been converted into a union territory. This is sanctioned under Article 3. But what about the remaining state, Jammu and Kashmir? The rest, the residue, the leftover? On that, there is no clarity. Supreme Court was asked, Supreme Court, please declare that this is unconstitutional. Supreme Court said, we won't answer for now. Why? Because the Solicitor General of India has given an assurance and undertaking before the court that the status, the UT status for Jammu and Kashmir is only temporary. We are going to restore statehood to Jammu and Kashmir. So that this constitutional vision, that means a part of the state can be made into a union territory, but the remaining part will remain a state. That vision will be intact. So this UT status for J&K is only for a temporary period. We are going to restore statehood to Jammu and Kashmir. The Supreme Court said, since the Solicitor General has given an assurance that we are going to restore statehood to Jammu and Kashmir, we will not answer this question as to whether it is right on part of the Parliament to convert the entire state into a union territory. This came under severe criticism. Why? Let's suppose I have been detained by the police arbitrarily, without me committing any crime, without me violating any law of the land. You will approach the court under Article 32. You will ask the Supreme Court, please issue the writ of habeas corpus and bring this individual to the court to see whether he was rightly or wrongly detained, arbitrarily detained, or reasonably detained. Can the government tell the Supreme Court, or the Solicitor General or the Attorney General tell the Supreme Court, my lord, this is not a permanent arrest. We have arrested him only for time being. We are going to release this individual. Don't worry. The courts cannot accept this argument. The court will have to look at the issue at hand and decide whether my detention is arbitrary or reasonable. If it is arbitrary, I should be set free. But here the court did not answer. So the court should have answered whether creating a union territory out of a state is constitutional or not, and whether downgrading the entire state into a union territory, whether it is constitutional or not. You can't listen or accept the argument of the Solicitor General. Why? Because what if there is a change in government and the government appoints a new Solicitor General, and that new Solicitor General says, whatever my predecessor had said, I am not going to abide by this, I have a different view. So you can't be listening and accepting the arguments of the Solicitor General in these cases. But that's not the only issue. The issue is related to federalism. And I told you what is federalism. Federalism means that there are two units, center and states. States are not subservient to the center. Both center and states, they derive their authority from the Constitution. So Constitution talks about that Parliament will have the power on these subjects, state legislatures will have the power on these subjects. The executive authority of the center will extend in these cases, the executive authority of the states will extend in these areas. Clear-cut separation of powers. But if you convert an entire state, for example, we had 29 states in 2019. One state was entirely downgraded to two union territories, J&K and Ladakh. But union territories, by their very nature, they are not states. They are directly controlled by the center. Even if in Jammu and Kashmir there is a legislative assembly, there is a democratically elected chief minister, but the real power is with the lieutenant governor who is appointed by the president. The real power is with the center, which means union territories are outcasts in federalism. Federalism and union territory, it is like an oxymoron. They can't exist at the same time. So if after 29 states, now we have 28 states, because one state is now bifurcated into two union territories, and these two union territories are directly controlled by the center, which means no dual government, no distribution of power. What stops a future government from converting the 28th state into a union territory or splitting it into multiple union territories? And then 27th, 25th, 10th, 9th, 8th, till we reach a point where Article 1 becomes a nullity. Article 1 would mean India, that is Bharat, shall be a union of states. No, shall be a union of union territories. And these union territories are directly controlled by the center. So when we say union of states means federalism, then it is not a federal structure. It is a unitary structure. Can Parliament have this power under Article 3 to convert our federal structure into a unitary structure? This question should have been answered by the court in Jammu and Kashmir Reorganization Act case, but unfortunately the court did not answer. But this is Article 3 of the Constitution, which is a centralizing tendency in Indian federalism, where although we are a federal polity, ours is a federal constitution, but our constitution is biased in favor of a strong center. That is why we use the term centralized federalism for India or quasi-federal for India. Or some would say India is not a federal polity. It is a unitary polity with some federal features. Some would say no, India is a federal polity, but with some unitary feature. But the apt term used for Indian constitution is that it is neither completely federal nor is it completely unitary. It's a beautiful mix of both. It is quasi-federal. This is Article 3 of the Constitution. If you have any doubts, do let me know in the comment section, and don't forget to press the like button. I'll see you next time. Till then, have a great time. All the best.